my talk, the first part is the important role of the mediator, as Jennifer said. That will be followed by Gordon, who will guide you through the process. You will see there's, of course, always some overlapping, but each of us will go into more detail in different areas. So Gordon's talk will be fully complementary to mine. I've revised the questions and answers, the questions we got yesterday, and we didn't have time for one interesting question we received, and that was about bad faith and mediation. So that person actually asked to give an example when mediation could be actually, let's say, possible in a bad faith case, because as we said, in counterfeiting and piracy cases, we strongly believe that mediation should not be an option, but in, let's say, classical bad faith, it might be. And I give you an example where we did a mediation. There was a company, a rather big company in the United States, and they, of course, also sold their products in the EU, European Union, and they had a distributor for the entire EU. And this distributor, without the consent, the specific, explicit consent of the US company, this EU distributor filed a European Union trademark, the trademark of the EU, of the United States company. And then, of course, when the United States company became aware of it, they filed an action before the EUIPO based on bad faith, saying that they didn't authorize the EU distributor to file that trademark. When we studied the file at the appeal level, we actually thought to suggest a mediation because we noticed immediately from the file that there were long-standing business relationship and common interest. And this is a good example because here, of course, from a legal point of view, the EU distributor probably acted in bad faith, filing the US trademark without the explicit consent of the company, US company. But the reason behind was that the EU distributor just wanted to make sure that they have trademark protection in the EU. So it was actually in the interest of the US company to have a trademark in the European Union. So at the end, the case could be settled and the parties continued to do business. So I think this is a good example of a, let's say, classical bad faith case, which could be, let's say, apt and suitable for mediation. Okay, I hope that I have answered this question. It was indeed a very, very good and interesting question. Let's now move a step forward. The role of the mediator, which indeed is very important, as all of us who are mediators here today know. I've drawn up a little drawing here. You can see to illustrate the role and the position of the mediator. Where you see here the mediator at the top, usually you have the judge, right? And then the judge tells the parties what they have to do and what they not have to do. But here you see, and there is no interaction before the court between the judge and the parties themselves and the lawyers and their lawyers. But here the mediator actually is also, let's say, has a kind of a position of a judge, meaning that he's a kind of facilitator between the two parties, but there is a constant interaction between the parties, their lawyers, and the mediator. And the focus here are the needs, the interest, eventually the emotion and perception of the parties. And that is what the mediator needs to take into consideration. So he has a role as a kind of facilitator to guide the parties through a process, whereas at the end, we have an amicable settlement. I think Gordon already showed you yesterday the different phases, and he will now, after my talk, go into more detail and explain each and every step in the mediation. But just to remind you, here in this 5 phases, the classical phases of mediation, the mediator has different roles. So the role is never static, it's dynamic. And the mediator must always act according to the phase where they are. And he must be very flexible and able to go a step back, to move a step forward, to switch between the phases. So basically, we can say that the mediator as a facilitator needs to be very agile and flexible and dynamic. So the most important role, of course, the mediator is to guide the parties through the mediation process. And I think it's very important to always remind the parties where we are at the mediation. Because, like I said, you have 5 phases, you go one by one, but it might be that you are in the bargaining phase, the, let's say, almost last phase, but you think that you have to go back to the exploration phase because you need more information. So here it's very important that the mediator always reminds the parties where we are. So if they want to go a step back, the mediator has to say, look, I think we are stuck here in the bargaining process. And it might be because all of us, we do not have yet the necessary information to continue with the fruitful bargaining. Therefore, I need to get more information. I need to explore again with both of you or with one of you. So we need to go back to the exploration phase, to the second phase. So it's very important. The mediator needs to give guidance and always tell the parties where they are in the process. Obviously, the mediator needs to facilitate the communication between the parties. I will come in a minute to it, and I will give you some ideas of how this is done with open questions and other techniques. And of course, the mediator needs to facilitate the formal procedure. So it's basically the five phases. They have to ensure that a mediation agreement is signed before the mediation. He needs to remind the parties that if necessary, the proceedings, for example, the appeal proceedings pending before us or court proceedings in other jurisdiction needs to be suspended. All these things needs to be, let's say, controlled by the mediator, and he needs to constantly remind the parties of the different steps in that procedure. And then the mediator has the most important role, which is, let's say, to facilitate, to help the parties that they get a global understanding of the global situation of the conflict. And that's not an easy task, but the mediator needs to take time in the exploration phase, the second phase after the opening of the mediation, and to spend time and explore the facts, and that the parties get an overall understanding of each other's positions and interests. And again, I said it yesterday, Gordon said it yesterday, we always encourage the parties to include all pending disputes in the mediation, to not only mediate, let's say, the appeal pending before our boards of appeal, but to also offer, we cannot insist, of course, but we offer and encourage actually the parties to include all their pending disputes so that we can really, truly find a global solution to the dispute. And then at the end, we should have a mediation agreement, which is then signed by the parties. And in this context, it's important to mention that the mediator is exempt from liability regarding the outcome, its legality and compliance with the settlement. That's very important. So the mediator is liable, and here we have to talk legal concept. He's liable or she's liable for the running of the mediation. He's liable on, let's say, the process is respected, confidentiality. All these things the mediator needs to control, and he or she is liable. But the outcome reached by the parties, that's the sole responsibility of the parties and their lawyers. And that's why it's so important that the lawyers are present in IP mediations, because they need to check and confirm that this settlement is according to law. It's not the responsibility of the mediator. There is always a tricky question, what should the mediator do if he sees that the parties agree on something which is clearly against the law? Maybe we have some time to discuss it either today or in June when we have our interactive session. Again, the liability is limited to the running of the process, outcome of the agreement of the mediation. This is a responsibility of the parties. And for us, if the mediation agreement is signed, it's a contract, a private contract. And if there is need to enforce that contract, then this is it would be done according to international private law. At the beginning of each mediation, and here I mean not only in the beginning when we meet all the parties, either online or in a physical meeting somewhere in Europe or elsewhere, the mediator means also already the first contact. When we call the parties, the lawyers, the very first contact, the most important thing is to build rapport and to gain trust and break the ice. I think this is a very, very important role of the mediator. Because if there is no trust, especially between the mediator and the lawyers and the parties, it's very difficult to move ahead. But also the mediator needs to try at least. That's very difficult because usually the parties coming to the mediator, agreeing to mediate, are entrenched in their positions, and they have sometimes a very long-standing conflict. So the mediator also needs to try to build trust between the parties themselves, not only between the mediator and the parties. That is crucial. The mediator also needs to guarantee at any stage during the proceedings to be neutral and impartial. That doesn't mean that the mediator is not active. On the contrary, it's very active, but the mediator should never take side of any of the parties during the entire process. And if, because we are all human beings, and it might be in some parties and lawyers, some human beings are very, very clever, and they may ask a question where you then notice, oh my God, I've actually said something which I should not have said. Address it openly. I said, look, you have to address it. You have to say, look, I might have lost here my neutrality and partiality. Address it even to the other parties, and then agree with the parties to continue or to stop, depending how serious that was. But be open, be frank, and transparent. That's very important. Communication, I have mentioned it. And with communication, I do not only mean the verbal communication, but also the body language. It gives a lot of information about the state, emotional state of the parties. So have a close look at the body language when you're listening to parties. It's not easy, but you get training for that. You can be trained for that, and it gives you a lot of information which you can use in order to unblock difficult situations. And if you or the mediator follows these, let's say, rules, automatically he will create a state of authority, because it's very important that the mediator has a kind of authority to the parties. It's not in meaning that he imposes his ideas. It's just that he controls the process and that he guides the parties through the mediation. And we discussed it yesterday, the knowledge of the process. That's also an important issue. And this is twofold. I mean, of course, the mediator needs to fully understand and control the process of a mediation, the different phases, the techniques. But in my personal opinion, the mediator ideally should also control and know about the subject matter, which is IP in our case. I gave you an example yesterday, and maybe we can discuss it also again at a later stage. But I think it's very important that the mediator knows about the subject matter and knows about the underlying legal questions. But of course, very importantly, during the mediation, he then needs to, let's say, disconnect from these legal concepts and again go to the business interest and guide the parties through. The knowledge is important to see and to always, let's say, control if one party is bluffing or going in, let's say, in a gray area, where you then can, private meeting can have a discussion with the lawyers or the parties. And of course, very important role of the mediator to always reconfirm the confidentiality at any stage. But this, I think Gordon will go into a bit more detail into different roles. The preparation. This is a very important phase where the mediator again plays a key role. Again, Gordon will explain that now in more detail. My only remark here for the role of the mediator is that I think that the mediator should ideally get as much as the possible information about the participants to the mediation, means to the companies, the CEOs, and the lawyers. In the age of internet, we find all that information everywhere. You get CVs, you get information on website about the business, and this gives you a lot of useful information which you can use during the mediation. Because don't forget, this is a business mediation. And if the parties, especially the CEO, sees that you start this question, so Mr. X, what is your company doing? I think they will look at you and say, what on earth are you asking me? Haven't you checked or don't you know even my company? Haven't you checked what they do? It's available on the internet. So they want to save time. They want to be effective. So I would suggest getting information and then reconfirming at the beginning if this is what they do. And then, of course, further digging into more details. But at the same time, very important, if you have this information about the companies, the parties, you shouldn't be biased. The mediator then needs to keep it in a cupboard in your head and needs to nevertheless listen very carefully, because the information might be, they may provide you additional, very important additional information or even different information. So keep the information in your mind, but be open for changes and new information. Also, very important is to always bear in mind the concerns of the lawyers and the parties. The mediator must understand what are the concerns of the parties and the lawyers in general, in order to address these concerns in the mediation if necessary. So, for example, the parties, for them it's important to understand the role and the cost, and what about the success. The lawyers, their concern are the legal aspect of the case. That's very important. I mean, if lawyers are present, you have to give them room, space in the mediation, and you also have to address their issues. And these are the legal issues. We said we want to focus on business issues, but nevertheless, if there are lawyers at the mediation, you also need to talk at least briefly about the legal issues in order to feel that make the lawyer part of the process. And then, of course, both will be concerned about the process of the mediation. So guide them through, as I said at the beginning. Issues of confidentiality, logistics, date and duration, all this needs to be ideally settled before the start of the mediation. Then, let's say after the opening, the role of the mediator is to guide the parties and to ask the adequate questions to get the full picture of the surrounding facts of the case, to understand the global IP dispute at hand. And this is appropriately done by open questions and hypothetical questions. One should avoid multiple questions, that's for sure. We all know that if you ask me now 3 questions at the same time, I will answer the first and I've forgotten the last 2. So that's a good example, because I guess that most of you are usually frequently speakers in conferences, and there's nothing worse if people ask you 2 or 3 questions at the same time, because you want to focus on the first one and you've forgotten the other one, especially if you don't have nothing to write down. So the best technique is 1 question, answer, next question. Here you see it also says avoid closed-end questions. Yes, but of course, sometimes you need to reconfirm. So you need to say, do you agree with that? That's an open that's a closed question, but you need it from time to time. But important is start with open question. How do you have to understand this situation? What were the surrounding circumstances of that conflict? Could you give me some more information about the opposition you have filed? All these are open questions and very useful at the beginning of a mediation. So that means the mediator should not questioning, should not investigating, should not interviewing. In exchange, the mediator should create an atmosphere of conversation. The mediator should be very curious. I think that's the key point. In our training, Gordon and I, we always said, just be curious. Just imagine you are sitting here with a friend or colleague, and you just want to understand what has happened. You don't stop with 1 question, because in trainings, when we train new mediators, we always see they asked 1 very good open question. So what was the main reason why you filed the opposition? Can you explain it a little bit to me? And then you get a lot of information. And in each verbal sentence, there is underlying information in it. So don't stop here. Dig into it and try to get more information. That's conversation. That's showing curiosity. And I think we all agree, use common sense. During the process, the mediator needs to move gradually, let's say, from the exploration phase to the bargaining and the solution phase. So he needs to develop, together with the parties, some options, some possible options. A brainstorming technique is very useful for this. I always ask the parties, come up with any ideas, even if they're absolutely unrealistic. It doesn't matter. It actually relaxes parties, and sometimes it's even funny. So I would say, look, come up with some ideas. It doesn't matter if they are realistic, unrealistic. We will see that later. That's the next step. That's the step of ranking and prioritization and evaluation the options. That's the next step. And always try to find options which are in accordance with the interest you have identified together with the party. And then, of course, reality testing is a very important technique. The mediator's role in the bargaining is also, of course, to assist the parties when preparing a first offer. And this first offer, I mean in particular an offer of money, of a payment, because usually in IP mediations, there is always money involved. And that's a very, very tricky issue, as all being mediators here today know it. There's nothing worse if you go to the other party and they said, he or she wants you to pay him $500,000 for that trademark. And then they will say, what on earth is that? And the first question will be, how has the other company calculated this? So it's very, very important to prepare the first offer very carefully by first exploring with the person who wants that money, who demands that money, to ask, how have you calculated this amount of money? And you will be surprised the answers you sometimes get. I remember a mediation I did with Gordon. You see, we have done a couple together, where we had a company, a huge multinational company on the one side, and a very small company on the other side. And the owner of that company, he wanted to have 500,000 euros. And we asked him, how have you calculated this 500,000? His answer was very easy. Before I came to the mediation today, I typed in Google, what's the best negotiation technique? And the first answer I got from Google was, always ask for the double of what you want. And we immediately said, so what you want is 250,000? And he said, yes. And that was actually the amount he could demonstrate by documents. So again, very important, assist the parties before they do the first offer. Find out about the information about the calculation, and then carefully check if this is an offer which could be in the, let's say, green zone of the other party, or it would actually be perceived as an offense by the other party. Here, the role of the lawyers are also very important. They can support the mediator when doing this exercise. And then we also have the techniques of Butner and Wagner, and I think Gordon is going a little bit more into detail in his talk. Very important, the role of the mediator when it comes to the identification of interest. Because you probably all know this triangle. When we are acting every day and every morning, we always have an issue. In business, in business terms, I'm talking now. There are always commercial interests, there are legal affairs, and there are personal matters. And they're related from the past, present to the future. So the mediator and the mediation usually starts in the past. People explain what had happened, and then we have to move gradually to present and then to the future. And while we're doing it, we need to find out what are the legal matters, which is the easiest part because usually we have the writs of the lawyers and the proceedings, so we know what the legal issues are. Then we have to find out what the commercial interests of that conflict are. That's already a bit more tricky. And if possible, we also should try to find out if there are personal matters. Because even if it is a business conflict, very often there are personal matters involved. Everybody wants to be respected. Everybody wants recognition. So these two things are very often key issues in mediations, in business mediations. So at least the mediator should try and explore a little bit if there is an issue with this. And always taking in consideration that there are positions and interest. And this difference is crucial because it is also the main difference between court proceedings, arbitration, and mediation. A position is something you decide to do. For example, I decide to file an opposition, or I ask the lawyer to file for me an opposition against another trademark, the trademark of my competitor. That's a position. That is what I want to do, or I want the lawyer to do. So that is easy to find out. But the interest is, what is the motivation why I have asked the lawyer or why I want to file an opposition? That's the interest. For the mediation, it's very helpful to find out the interest, the reason why this company has filed an opposition. And sometimes you will just hear, okay, because this person just had filed a very similar trademark for similar goods and services. But sometimes you hear that actually, yes, that is my competitor. He's coming into my market. And then you dig into it and you actually find out that they would be interested to cooperate. So there may be many, many different situations. The key point here is just to first identify the positions, find out what the interests are behind, and see if there is some coincidence in these interests, and that maybe even you can create and enlarge the pie, as I said yesterday. And then at the last point, the mediator role in when settling or when drafting the settlement agreement. So he needs to check if it's feasible, achievable, and enforceable. I said the lawyer is not liable. The mediator is not liable for the outcome and the enforcement. But nevertheless, the mediator, with its experience, can of course go through the agreement and say, look, I think this is difficult to enforce in the future, if necessary. So he can, of course, give and guide the parties through that and give some support. And very important, the mediator needs to check at any time if the solutions drafted, written down, are okay with all the parties. Because sometimes you might have a situation that the party immediately said yes to everything. And that's actually a sign where you have to go in a private meeting with that party to find out if there is really everything okay. Because some parties don't want to, in a joint meeting, say that they strongly disagree. It's also a question of culture, diversity, and differences. So very important, the mediator must reconfirm that the solution found is satisfactory for all the parties. Ideally, the agreement should also include a clause the clauses should include the possibility to settle all the pending disputes between the parties. Now, as I said, Gordon said yesterday, we can include other IP rights, other conflicts before other courts. So all this should be part of the settlement agreement. And of course, the agreement should minimize the risk for future disputes. And we would also recommend to include a clause in the contract, in the agreement, saying that if there is a conflict during the lifetime of that mediation agreement, that settlement agreement, it should be again derived for mediation. So you make a clause, and then before you go to the court, or before you enforce the settlement agreement, you give again mediation a try. And it must be in writing. I think this is obvious for IP conflicts. And in here, maybe it's interesting to mention, even, for example, let's imagine we usually invite the parties for one day to come to Alicante, or we do it online. But sometimes the conflict is too complex and you cannot, let's say, reach an agreement a signed agreement in that day, because the lawyers need to have time to draft the exact clauses of the contract. However, it is very important that at least the parties agree on a kind of roadmap. So if there is no time to draft a contract, a settlement agreement, at least they should draft, the parties with the help of the mediator and the lawyers should draft a kind of roadmap where it is very clearly described what every party has to do or not to do, in order to not lose any information and not leave any uncertainty after the conclusion of the mediation day. And if necessary, the mediator at the later stage can pop in again if there is a problem while it's drafting the contract and the parties need further assistance because they are, let's say, discussing a specific item of the contract and they can't agree. So they could then contact the mediator again. And of course, I said that in the beginning, but I would like to mention it again. The best agreement comes from the parties, not the mediator. And this is also a very tricky issue because, I mean, the more mediations you do or you've done, the more you have seen different solutions, also sometimes very creative solutions. So it is, of course, sometimes very tentative to give a solution to the parties. But I think we need to be very careful. We first need to try that the parties find the solution themselves before we intervene. And of course, if the parties are stuck and cannot really come up with good solution, creative solution, and you have one which you think is very suitable for settling the present dispute, what you can do, you can introduce your idea by saying, listen, I've been involved recently in a mediation, and I was surprised to see the solution the parties found in a similar conflict. And then you can ask them, do you want me to show you the settlement, the clauses they could agree on? And then the parties can either decide, yeah, that's interesting, or they take it as a starting point, and from there they continue the agreement, the drafting of the agreement. So again, and I will finish with this last sentence again, the mediator has a very important role. He needs to guide the parties. He needs to show authority. He needs to be flexible. But at the same time, he needs to leave room to the parties. It's not the mediator. It's not the main person. It's the parties and their lawyers. So don't misunderstand the role. Give room to the parties. Explore the underlying surrounding facts with the parties and guide them through the process. And then you hopefully find an amicable settlement which will conclude the pending disputes. Now I'm again looking forward to your question. Thank you very much.
Thank you very much, Sven. We can now proceed to the Q&A portion. So we have a couple of questions. First is, in cases where the mediation process is successful and parties sign an agreement, but there is a subsequent breach, can the agreement be subject to court proceedings for enforcement?
I mean, can you repeat the question, please, Jennifer?
Sure. So, for example, when the mediation process is successful and a mediation agreement, a compromise agreement results from the process, but then afterwards there is a breach by one of the parties, so they do not follow the provisions in the agreement, can the other party bring this to court for possible enforcement or damages from such breach?
Yeah. Okay, yes, I mean, first of all, let's hope that this situation doesn't occur, but of course we need to be realistic, and it might be that one of the party doesn't comply with the agreement, so it would be then a breach of the agreement. And as I said, my recommendation would be first to have a clause in that agreement that in case somebody is breaching the agreement, you refer it first to mediation again. And then if this doesn't help or you don't have this clause, then of course it's a private contract, as I said at the beginning, according to international law, depending where the parties come from, and then you will take it to the court. And then it would be the judge to rule over this conflict. But again, if you have reached the agreement, I would strongly recommend to first try at least a kind of a short, quick mediation to see if you can't settle this via another mediation. I don't know. I think Gordon is here as well. Gordon, if you have further input, just step in, yeah?
Can you unmute me? Yes. Hello. Hopefully, can you hear me now?
Yes.
Yes. Okay. Yeah, I would just say that of course you can always, in these situations, it would depend on the provision put, as you said, Sven, put in the settlement agreement. Particularly the applicable law to that provision. So, as I said yesterday, in Spain and a number of the continental European countries, it's possible to do one of two things. Either you can take your settlement agreement to a notary public. Here in Spain, we're very keen on our notaries, and you can get the document authenticated by the notary, and thereby it becomes immediately enforceable by a court. The second option is, that's under Spanish law. The second option is that you take your settlement agreement to a court, and you ask them to write it into a judgment. That's also possible. The disadvantage, as I said yesterday with that, is it then becomes public, the content of that settlement agreement, which obviously has disadvantages with the confidential nature of the whole process. But these are other possibilities as well. Thanks.
Yeah, thank you, Gordon. I mean, this is very important, what Gordon has said, that you ideally should also have a clause. I mean, all the lawyers amongst you, you know that perfectly, to agree on the jurisdiction which is applicable. That's very important. But this is difficult also because it depends on the jurisdiction. I mean, as Gordon has said, in Spain you have, I mean, only in the EU we have very different rules. And I mean, in your countries it will be different, even more different. So it's important also to inform you about the different rules and laws, and then apply this in the agreements. We have another question, Jennifer?
Okay. The second one is assuming that the mediation agreement includes a non-disclosure clause for both the mediator and the parties, what happens if the confidentiality clause is breached, especially when the dispute comes across several jurisdictions?
Yeah. That's a very good question. I mean, first of all, confidentiality is a tricky thing. And, it depends on the degree of confidentiality. And I think parties will never, even if you try, they will never give you all the information you would ideally like to have, because there is no guarantee. Because if there is a breach of confidentiality, you can, of course, sue that party. And if necessary, if it's a multi-jurisdictional conflict, you have to sue this party then in at least in the country where this company has its seat, or the person has his address, or maybe even other countries. So that is then, let's say again, civil or even penal proceedings, depending on the exact breach of confidentiality. But in order to avoid this, I mean, again, first you mentioned that in the clause, we, for example, made all parties, including the mediators and the lawyers, to sign confidentiality agreement even upfront before the beginning of the start of the mediation. It's not only mentioned in the mediation agreement, it's not only mentioned in the settlement agreement, but it's also an individual additional kind of contract where everybody has to sign the confidentiality assurance agreement. But that's why it is important, I think, to have private meetings, because in private meetings you can actually get confidential information more easily. And then, of course, you don't reveal that to the other parties. Again, this is digging into facts to understand the conflicts in a private meeting and to get all the information or try to get all the information, including the confidential information, because the party and the lawyers will probably more open to disclose confidential information only to you as a mediator as to the other party. And then you go to the other parties, but you don't disclose the information. You disclose the underlying interest of that information. And that's the crucial point in mediation. So you don't give the information, the confidential information, but you agree with this party or this company, what is the underlying issue here with this confidential information? You have financial problems. They tell you, look, I have lost all my clients now due to COVID. But of course, you don't want your competitor to know about that. But it's not an issue. You can just go to the other party and say, look, and the other company is actually facing some financial difficulties. That's an issue. That's an interest. That's if the other party says, well, you can reveal this, but you don't give more details. So I think important is in the mediation to first not disclose absolutely strictly confidential information to the other parties. In any case, the company will not allow you to do it. So it stays between the mediator and the respective party. And then you have the three, let's say, confidential steps in the agreement, the mediation agreement, the mediation settlement agreement, and an additional clause. And if there is still breach of confidentiality, then you need to sue the party. Gordon, you have...
Yeah, just one thing. I mean, occasionally it can happen that, in fact, confidentiality, there's no such thing as an absolute guarantee of confidentiality, because you can have situations where there's an overriding imperative of law that forces, say, the mediator or one of the parties to actually reveal information that was given in the mediation. For example, if the mediator is subpoenaed to court in a jurisdiction where they don't recognize the confidentiality clause in the contract. Just an example I have in mind is apparently in Hong Kong. I have no first-hand experience of this, but I'm told that in Hong Kong, the courts will not be bound. They consider themselves not bound by confidentiality clauses in mediation agreements. So that's just something to be aware of. And there, I think, then there wouldn't be a question of liability of either the parties or the mediator. In fact, in our mediation agreement, we have a clause that specifically says, unless there's an overriding requirement of law. Just to add that in. Thanks.
Thank you, Gordon. And also, please, and confidentiality has another aspect, because the parties, if you go into the private session, they will always say, look, Mr. Stürmann, Mr. Humphreys, or whoever, Gordon, Sven, this is confidential information. Don't disclose it. And then I tell them, but I have just read it yesterday on the internet, this information. So what to say, you have to, don't accept when they said this is confidential. You say, okay, this is very important. I will, of course, not disclose it. And then you say, but actually, this is either I've seen it on the internet, I've read it, or very often it's part of the file, of the court file, of the file of the proceedings before the IPO. And then it's not confidential information any longer, because, again, you also have to have clear, you can't move forward if everything is confidential. You have to at least disclose something. And very often it is actually information which is not confidential, but of course the parties like to say everything is confidential. So use common sense. And if you know that the information the party has just given you is part of the file, you can say very respectfully, say, look, I think, is it really confidential? Because this is part of the file. I've read it, and this writ was sent to the other party. Yeah. So first check if the information is really confidential. If it is, give a clear and firm commitment that you will not reveal that unless the party allows you to do so. Okay, Jennifer, another one?
Thanks for that. So the next one is, in terms of the issues to be considered, should we prioritize the legal or substantive merits or aspect of the case, or business interests? Or can the parties agree on what issues should be prioritized in the mediation proceedings?
Okay, that's also a good question. I mean, I think the key word is here first flexibility, and also to see who's at the table and who's more active at the table. Because you may have a mediation with lawyers and parties where the lawyers are completely silent because they say, look, this is about the parties. I will just be here for you in case you need me. And then, of course, I would say you address briefly the legal issues and then you move forward to the business interest because you have the parties primarily who want to talk. But I've had a mediation where the party always said, no, I don't need to talk. It's my lawyers who will speak for me. And then, of course, I think it's probably more important and strategically better if you start with the legal issue because that's what the lawyer feels most comfortable with. So you start with the legal issue and then you try to move gradually forward to the business interest. And then you also need to convince the party who said, no, it's the lawyer who will speak for me to get and involve this party. So it depends on the situation. You need flexibility, but I think, again, a mediation cannot be done solely on the basis of exchange of legal arguments. I mean, that would be not the purpose of the mediation. But maybe, Gordon, I don't know if you have another view or.
No, I think I agree with everything you've said. Just to say that in the next webinar, I'll explain that we draw up an agenda with the parties in the first joint meeting, where we look at the issues to be discussed, and normally some prioritization would be made of those issues in that joint meeting. So I think the last part of that question about is it the parties that decide, I think that's really, of course, the whole idea of mediation is that it's the parties that that help shape the process, that the mediator drives the process, but at the end of the day, it's about the parties, and therefore what's most important to them is what we have to look at first. Thanks.
There's another aspect, I think you go on, because the lawyers are have the key role in especially business and IP mediations. And they can be partners of the mediation. If they understand the mediation process and if they are favorable to it, they are very powerful to, let's say, to assist the mediator in moving forward. Because don't forget, I mean, we have many lawyers here, you know that. At the end of the day, the party will go to a private room and ask the lawyer, do you agree with this? Can I sign that? Is this okay? And that's crucial. And here the lawyer has a key role. He needs to, or she needs to be involved from the very beginning. And we need them as partners in the mediation because they will, at the end, it's the parties' deal. That is true. But nevertheless, they will always reconfirm in the private session where even the mediator is not present. What do you think? Can I sign that? So lawyers have a key role in this process.
Yeah. Sorry, go ahead.
Go on, step in.
Well, I was just going to say, and that's the reason why you absolutely have to keep, as a mediator, the lawyers on your side. You must never say anything that antagonizes them or belittles them in any way in front of their clients. For example, with the reality testing, you mustn't make the reality testing look like the lawyer's done a bad job and been unrealistic about his or her client's prospects. Thanks.
But at the same time, it might be because you might have lawyers who are sometimes not so favorable and are a bit entrenched in the legal positions, to be honest. And in this case, it also might be recommended to have a private session with the lawyer. I gave you the example yesterday, and where the lawyer was clearly bluffing. I mean, it was clever. There's nothing against. I would have done exactly the same. But that was crucial to go in a private meeting only with the lawyer, because you should never challenge the lawyer before the other parties and the client. I mean, this is the kind of respect. No, so it's very important. But go then into a caucus, a private session with the lawyer, and address it very kindly and discuss this matter. That's very helpful. Okay, another one.
Okay, for the fourth one. So the question is, in some cases, when one party's corporate decision maker is not willing to proceed with mediation, how can mediators or colleagues from the IP offices deal with this problem, since the decision maker is abroad and may not be familiar with the intricacies of each case or even the chances of success of mediation. So it's like a lost opportunity for mediation.
I mean, to be honest, I don't understand really this question. So is it, I mean, if the party doesn't want to mediate, then they will never engage. Have they engaged and they want to stop? I mean, mediation is a process where everybody can opt out at any stage without giving any reasoning. So there is no, and I said that, you remember yesterday, I said the parties, that's why I said over the very beginning, if you engage into mediation, you have to understand and you have to agree to the give and take approach. If that is not the case, you better stop. But this can change even during the mediation, that the party said, no, I don't want to give anything. I'm not agreeing to anything. And then, of course, the party can step out. And then you would just terminate the mediation and refer back the case to the proceedings, to the normal proceeding, court proceeding, or IPO proceedings.
Yeah. Maybe I can just come in on the last part of this question, which is what would happen if the key decision maker is abroad and not willing to attend. I mean, actually, this is quite a frequent occurrence. I have a mediation at the moment where one of the CEO of one of the parties is based in Silicon Valley in the US, and it's highly unlikely, even if the COVID-19 situation gets better very shortly and we're able to have a physical meeting, it's very unlikely that he's going to take the time away from his multi-million-dollar business to come to Alicante and discuss the case. He'll send somebody else to do it. But what we do in these situations is we envisage a phone link or a conference call by a video conference, preferably, with the person in question. And this is especially necessary with the time differences because, even if we do everything online, there's a 9-hour time difference between Alicante and the west coast of the USA. When we're finishing our day, they're starting our day. So unless we want to stay up all night doing the mediation, we have to basically progress as much as we can without the CEO, and then bring him in for the key points. And of course, that's actually much better for these people because they don't want to be listening the whole day to the whole history of what happened. They just want, what's your question and what do you need answers to? And you have to be very targeted and respect their time. Thanks.
Okay, for the next question, what do you think about parties not wanting to put their agreement in writing, but simply filing a joint motion to dismiss the case because a settlement has already been reached?
Again, I mean, this is up to the parties. I would always strongly recommend to at least have a short written agreement. But the parties, if they agree just to say, look, I withdraw my action here in the opposition or the cancellation, and that's fine with us. It's up to the parties. But I would strongly say, as a mediator, I would just say, okay, this is your case and this is your settlement. And I would recommend to at least have a very short road map explaining or describing exactly what step has to be done by everyone in order to avoid that later on there are misunderstandings or one party doesn't do what he or she should have done. So that's what my recommendation. But if they still said, no, we don't want it, it's their deal.
Yeah,
okay.
Just to add that, as I'll explain in the next webinar, in any case, if they do settle, they're always going to need to withdraw the proceedings before the EUIPO. So that's just a given in this situation that's going to happen. We need to see that in order for the mediation to have been successful.
Yeah, that's very good because I remember one of the first mediation, the parties found a settlement, but then nobody withdrew the appeal. And after half a year, we noticed the case is still pending. The parties were doing business, were extremely happy, but they forgot, because they should have known, but we also forgot to tell them. that, as was Gordon said, you have to withdraw the appeal because you found a settlement. So that's an important point. Yeah. Thank you, Gordon. Another one, Jennifer?
Okay. Yes. Last one, I think we have time for. Can an external technical expert be invited to give advice on the technical aspects of the case? And will this be helpful for reaching a mediation agreement?
That's an excellent question. And the short answer is yes, of course, if both parties agree. Yeah. So I give you an example. I remember several mediations I did in trademark disputes. And in the end, we always come to a point where both parties said, we have so wonderful trademarks. We can go after everybody in the EU because our trademark is so strong. Although I know that this trademark is actually completely descriptive or very weak, and it doesn't have so much scope of protection as the lawyer and the parties pretend that it has. So here, it can be very useful to get a technical expert giving an expert determination of the strengths of the trademark. Yeah? The same for patents and other IP rights. This is a crucial part. And then we come into the discussion of hybrids. Yeah? We have alternative dispute resolution, and we should also be open to combine the different things. So we can start with a mediation. But then if we come to this situation I've described, where a patent is challenged and the parties say, no, my patent is wonderful. And then you can suggest as a mediator, okay, I think this is a crucial issue here. Otherwise, it's difficult to move forward in the negotiations. So what about asking for an expert determination, expert opinion, a technical opinion on the validity of the patent, on the strengths of the trademark? So the answer is yes, very good idea. And but of course, it needs to be agreed by both parties. Yeah, that's for sure. You can't do it and just say, okay, I will now bring it forward. I want this. You need to agree with the other parties, but it's very helpful.
Yeah, I just chime in here saying that there's one thing you've got to be careful about is the parties often misunderstand at the beginning, particularly the lawyers, and if they've never been involved in a mediation previously, they misunderstand the role of the mediator, and they see the mediator as a judge or arbitrator who's actually going to decide the case. And they start trying to plead to the bench, to convince the judge, you as mediator, that they've got the better case. So technical experts are useful and good, but at the end of the day, it's really about are the expectations, if the case were to be brought to court, of being able to win the case at court, are those expectations realistic or are they not? Or, how realistic are they? That's where the legal aspect comes in. But it's not about trying to say, oh, I'm the winner in this case and you're the loser, and trying to convince the mediators. So provided the parties all understand what the purpose of doing this is, it can be useful.
Okay, Jennifer, I think we need to move now to Gordon, but if you allow me, I've seen there's one question. I can give a very short answer because it's a very important question in our international context here. And this is the question on if the mediator can be selected by the parties and how many mediator in one case. So that's a very good question. I mean, especially in international mediations, you usually have companies and people sitting at the table coming from different culture backgrounds and different languages. So co-mediation is very important here. So whenever you have these kind of disputes where you have companies come from different jurisdictions, it might be useful to appoint two mediators. But if you do so, very important, the mediator should then not understand their role. I'm the German. I'm defending the German client. Gordon is the British. He's defending the Brits. No, we both are mediators. We both are impartial, and we both are neutral and work for both parties. That's very important. But again, sometimes co-mediation can be very useful. Also, because the parties don't want, in this case, I've said the parties don't want only a German mediator if one party is German. So that's a good question. In these situations, co-mediation can be very helpful. Okay, thank you very much for your questions, and I pass the floor to Gordon.
Thank you for that, Sven.